Hello and welcome along to today's webinar, HR and Employment Law Mythbusters. My name is Rachel Lamsley and I'm a Senior Employment Law Advisor here at Ellis Whittam. So for those who are unfamiliar with EW, we provide high quality, fixed fee employment law and health and safety advice. We employ qualified solicitors and health and safety advisors who develop one-to-one relationships with our clients as we provide you with a named advisor to help you along with your HR and health and safety journey. We don't just advise, we provide hands-on support, and a range of additional services are available to our clients. We currently have more than 17,500 UK employers that we're supporting, from startups to national brands, and we really are experts in our field. Our clients are pretty happy too, and we're currently running at a more than 95% client satisfaction rate, something that we're really proud of here at Ellis Whittam. So before we get started, let's talk about a couple of bits of housekeeping. To listen to today's webinar, please use your computer speakers, and you will also receive a summary of today's webinar after the event. If you're having any trouble at all accessing the webinar today, just let me know in the questions box and I will come back to you after the event. So why not join in our conversation today on Twitter by using our hashtag EWMythbusters. What are we going to have a chat about today? Well, we're going to talk through some myths in respect of recruitment in pregnancy, contracts of employment, probationary periods, redundancy, time off for dependents, bank holidays, disciplinary suspension, and unfair dismissal rights. But why is it so important to make sure that we don't get caught out by these myths? Well, getting it wrong can land us in the employment tribunal, and that can be quite costly. Let's take a look at a claim for discrimination, for example. If an employee brings a claim for discrimination, well, the losses are uncapped, and it really is up to a judge, taking into account the evidence, what level of compensation to be awarded. Discrimination awards can go from anything from around £660 into the hundreds and thousands, depending on the severity of the complaint being made. In 2015-16, the highest award for sex discrimination was £1.72 million, with the mean being £85,622. Can your organisation afford to wrongly discriminate? Whilst not uncapped, unfair dismissal claims also carry a significant financial penalty if employees get it wrong. And it's not a defence to say that you didn't know the law or believed something that turned out to be a myth. Claims for unfair dismissal carry a basic award, which is the equivalent to a redundancy payment, and a compensatory element that is capped at either 52 weeks gross pay or just little over £80,000, whichever is lower. The mean for unfair dismissal claims in 2015-16 was £13,851. Not really an attractive sum to have to pay if we get it wrong. But the story doesn't end there. Claims and awards can be made for claims relating to time off dependence and working time, claims for annual leave, in which a judge can decide to award a sum that they consider just and equitable. But what is that, and how do we calculate what is just and equitable? Well, in the example of time off for dependents, as I say, they can make the award for compensation that it considers just and equitable. And what they will do is they will have regard to the employer's default in refusing to permit the employee to take the time off and any losses sustained by the employee. There has been case law which has awarded around £1,000. Perhaps the biggest myth that I come across are those surrounding automatic unfair dismissal. These are claims that carry uncapped awards for compensation, and it's a daunting prospect to have to walk into the tribunal not knowing the worst case scenario. One claim from a prison officer for whistleblowing reached £477,000, almost £500,000. What would that do to your organisation? So let's get myth busting and avoid ending up in front of a judge explaining why we got it wrong. So, myth number one is in respect of pregnancy and recruitment. That is that during the recruitment process, women have a legal duty to reveal that they are pregnant. This is a myth. You might be surprised to know that women are under no legal obligation to reveal that they are pregnant. I appreciate how concerning that is. What if you're looking for someone to cover maternity leave, or you need someone in post to create some continuity? If an applicant volunteers the information, it shouldn't be taken into account in deciding whether to offer the role. An employer should only consider if the person can do the job and if they want to do it. Unfortunately, asking someone if they're pregnant or making inquiries about whether they are married, have children, or plan to have children is a surefire way to get a claim for discrimination land on your desk. A discrimination claim can be issued despite the individual not being offered employment with you. They can bring a pre-employment discrimination claim, and these claims are uncapped in terms of compensation. So, be aware, there's no obligation on an applicant to disclose that they are pregnant, and any questions relating to an applicant's marital status or plan to have children could result in a claim for discrimination. So let's move on to our second myth in respect of contracts of employment. That is that contracts of employment need to be in written form to be legally binding. This is also not true. A contract may be written and signed as a document, but equally it may be a verbal agreement made between the parties. Simply because a contract was made verbally doesn't make it any less valid, and the individual will still be considered an employee. Something that is worth bearing in mind, though, is that despite a verbal contract being legally binding, there are additional obligations on an employer. If you enter into an employment relationship verbally, you are still required to provide each employee whose employment is to continue for more than a month with a statement of written particulars of employment. An employee has the right to receive that, and what it is essentially a contract of employment that contains certain information such as name, job title, pay, annual leave entitlement, plus a whole host of other elements. This must be provided within 2 months of the employee's start date. Failing to provide this can result in a claim being issued in the tribunal for failure to provide the statement of written particulars of employment. So it's worth popping a note in your diary to remind yourself to provide one, so as not to forget. So on to the next. So the myth that holidays and notice rights don't start to accrue until the completion of a probationary period. Well, you've probably guessed it, that isn't quite true, and rights to annual leave and notice are not dependent on the completion of a probationary period. Annual leave is actually a day one right. Under the working time regulations, a worker, so not just an employee, can bring a claim in the employment tribunal if the employer doesn't, for example, allow them to take their statutory leave entitlement, pay them in respect of unused leave on termination of employment, or pay them a week's pay for each week of leave that they have. Where an employer fails to pay holiday, the worker can seek the amount due. Don't forget, statutory minimum entitlement to holidays is 5.6 weeks, which can obviously be prorated for part-time staff. Now, whilst you can improve that annual leave entitlement, you certainly can't reduce it. From a notice perspective, there are 2 types of notice periods: statutory and contractual. Statutory notice is the minimum legal notice that can be given. From this perspective, employers should give the employee 1 week's notice if the employee has been employed by the employer continuously for 1 month or more, but for less than 2 years. After 2 years complete service, the employee is entitled to 1 week's notice for each complete year of service, up to a maximum of 12. Employees, on the other hand, from a statutory perspective, must only give their employer a minimum of 1 week's notice once they've worked for longer than a month. Just a note on this, the employee's minimum notice is unaffected by longer service. In terms of contractual notice, this is slightly different. This is the amount of notice that the employer can set out in the terms and conditions, which can be longer than the statutory notice, but certainly not less. For example, the statutory notice of an employee that they must give to an employer is 1 week after a month's service. However, an employer can state within the terms of employment that the employee must give, say for example, a month. What we've got to bear in mind that any employer's failure to provide the correct period of notice can result in a claim for wrongful dismissal or breach of contract. So it's certainly worth making sure that we get it right. So, what are the myths out there in respect of redundancy? Well, let's take a look. The myth, last in, first out, is a fair way to select employees for redundancy. Unfortunately, that's not quite right. This used to be a common way to select employees for redundancy, but it's not a good idea to have this as your only selection criteria, as it could give rise to a claim for age discrimination. The reason being that it's more likely that your younger employees will be at a particular disadvantage because they're also more likely to have the least amount of service in comparison to your older employees. If you're going through a selection process, then you should use a range of criteria which must all be fair and non-discriminatory. In order for it to be reasonable, the redundancy selection criteria should, as far as possible, be both objective and capable of independent verification. This means that the criteria should be measurable rather than just being based on personal opinion, which I know is sometimes hard to avoid. Objective criteria could include disciplinary records, skills, experience, and work performance if there are objective ways to score that fairly. Be wary, though, of not only last in, first out, but also attitude, cost savings, and blanket uses of attendance records. Attendance records use could give rise to a disability discrimination claim if not used appropriately. My top tip here? Take advice. Selection criteria can be tricky to negotiate and can land you in hot water, so take advice on what works best for your organisation. The second myth in respect of redundancy is that all employees are entitled to receive a statutory redundancy payment. Nope, another urban myth that isn't quite right. Employees with at least 2 years of continuous service are entitled to receive statutory redundancy pay. If an employee unreasonably refuses to accept any suitable alternative that you might offer, they potentially could lose that statutory right to redundancy pay. But that, again, is one to take advice on. So, today we wanted to get through as much as we possibly could. So our next myth is in respect of time off for dependents. That being that employees can book time off in advance for dependents leave. You've probably guessed it, that's not quite right. The position in respect of time off for dependents is that this should be to deal with emergencies and unforeseen matters involving dependents. If the employee knows in advance, however, that they're going to need the time off, they may be able to arrange this with the employer by taking another form of leave, such as parental or annual leave. However, the mere fact that the employee knows in advance, for example, that they're going to have a problem with childcare arrangements on a particular day, doesn't prevent them having the right to time off if they're unable to make alternative arrangements in the meantime. It is a tricky area, so let's take a look at this in a little bit more detail. This right applies to employees only, rather than workers or self-employed people, and there's no qualifying length of service requirement to have the right. So like annual leave, it's a day one right. A dependent can be the employee's husband, wife or partner, child, parent, or someone living with them as part of their family who could be considered depending on the employee. Others who rely solely on the employer for help in emergency may also qualify. In terms of an emergency, for the purposes of time off for dependents, this could be where a dependent needs assistance because they perhaps have fallen ill, given birth, or been injured or assaulted. The other examples could include the employee needing to make arrangements for the provision of care for a dependent who is ill or injured, and for a dependent who perhaps may have passed away. Other examples include the employees needing to deal with an incident involving the employee's child, which perhaps occurs unexpectedly at a time when school is responsible for the child's care. Finally, it includes the employee needing to deal with an unexpected disruption or breakdown in care arrangements, for example, for a parent or child. Other life problems, however, for example, a leak or a broken boiler, are not considered emergencies for the purposes of this type of leave. In terms of the amount of time that they can take off, Employees can only take off as much time as it takes to deal with the immediate emergency. For example, if a dependent is ill, they can take enough time off to deal with the initial needs, such as taking them to the doctor and arranging for their care. Employees cannot take time off, however, to provide continuing care themselves, and they'll need to make alternative arrangements for that. If the employee wants to stay off work longer to provide the care, they will normally need to take this as part of their annual leave entitlement. As a general benchmark, no more than a day or so should be necessary, but unfortunately there's just no set guidance from legislation that sets out what an appropriate amount of time is. No request for time off should be unreasonably refused by the employer, and an employer can't refuse on the grounds of business reasons. The only objection an employer can make is that the employee is taking an unreasonable amount of time off. Again, this is a tricky area because when does it become unreasonable? If there is evidence of abuse of the right, then the matter should be dealt with by way of the disciplinary process, and I would suggest that before embarking down that route, you take advice. An unreasonable refusal by an employer could result in the employee bringing an employment tribunal claim for constructive dismissal, for example, or even indirect sex discrimination. In terms of notice, the employees must tell the employer as soon as possible why they are away from work and how long they expect to be off. In extreme cases of emergency, where employees cannot inform the company of their absence before their return to work, then on their return they should inform their supervisor or line manager of the reasons why they were absent. So, moving on to myth number 6 in respect of bank holidays. The myth being that employees are entitled to have bank holidays off work or to be paid extra for working. As I'm sure you've guessed, that's a myth. And it's not quite right. Employees do not automatically have the right to the day off on a bank holiday. Equally, there's no obligation on employers to pay the employee anything extra, for example, time and a half or double time for working the bank holiday. Employers do need to be aware, however, that contracts might give employees these rights, or there might be a custom and practice of paying time and a half or closing on a particular bank holiday. If this applies to you, then take advice before altering the way you deal with bank holidays. It is possible to change the terms and conditions, for example, by way of agreement with the employee or by potential other means. However, you do need to be wary of potential constructive dismissal claims, and so do take advice if you're looking to alter the terms and conditions. Now, on to myth 7, that you've always got to suspend an employee if you're investigating allegations of misconduct. Whilst this could be the view in some particular circumstances, it's certainly not something that we would suggest as a knee-jerk reaction. Employers should consider whether the employee should be suspended on full pay whilst the investigation is being completed, not immediately jump to suspension without considering all options. Suspension should really only be taken in respect of very serious issues of gross misconduct and should be a last resort and not to be taken as a given. Suspension should only be in certain cases. For example, if there's a risk that the employee could tamper with evidence or continue to pose a risk to your business. There have been cases where it was found that the employer failed to consider whether suspension could be avoided, resulting in a finding that there had been a breach of mutual trust and confidence by the employer. In the case of Gogay in Herefordshire County Council, the Court of Appeal awarded damages for psychiatric illness suffered by a care worker in a children's home as a result of her suspension following allegations of sexual abuse. When the employer looked into the allegations, there was no evidence on the face of it that she could have committed the act of gross misconduct. In another case of Crawford and another and Suffolk Mental Health Partnership NHS Trust, the Court of Appeal held that an NHS Trust had been wrong to suspend 2 long-standing nurses with no previous disciplinary record pending its investigations into allegations that they had tied a patient with dementia to a chair. In this case, alternatives should have been taken into account before suspension was taken, so it's always worth bearing in mind that you should take advice and only make the decision when appropriate. Suspending someone unreasonably can result in a breach of the mutual trust and confidence, and so it shouldn't be dealt out lightly. The length of suspension should also be kept under review. If the decision to suspend is made, then we also need to keep this under strict review. In the case of Camden and Islington Mental Health and Social Care Trust in Atkinson, the Employment Appeals Tribunal upheld the tribunal's decision that an employee had been constructively dismissed because her employer had failed to review her period of suspension and lift the suspension at the appropriate time. Suspensions shouldn't continue to run without it being reviewed and deemed appropriate. So make sure we always take into account all options when considering suspension. So, my final myth for today is in respect of dismissals, namely that employees with less than 2 years service do not have the right to make a claim for unfair dismissal. This is where many employers trip up. Irrespective of service, an employee can make a claim for automatic unfair dismissal, and there's a number of reasons when this may apply. If an individual is dismissed because they've perhaps taken some maternity leave or are pregnant, an employee is able to bring a claim for automatic unfair dismissal. This is also the case in respect of whistleblowing and asserting a statutory right. The story doesn't end there. Further examples of automatic unfair dismissal could be in respect of employees being dismissed perhaps because they took some adoption leave, or they were dismissed because they are part-time or fixed term. And finally, if an individual raises health and safety issues and they're dismissed as a result of that, they too can bring a claim for automatic unfair dismissal. Even if an employee has only worked with you for a few hours and they are dismissed for any of the reasons that we've just talked about, then they can bring a claim against the employer, which carries an uncapped compensatory award should we lose in the tribunal. These types of claims don't always present themselves in the most obvious way, and they can be masked within a grievance or raised verbally with a manager. It's therefore really important to ensure that your managers are trained and they know how to spot issues like these before they escalate. So there are so many more myths to bust, and we would be here all day if we tried to do them all. Other questions that might need answering is, well, what's a disability? Could that include depression? Can an employee bring a claim for race discrimination on the grounds of harassment, even if they don't have a protected characteristic? And what about those whistleblowers? Does the information that a whistleblower discloses need to be true? Here at Ellis Whittam, we help you bust all of those myths to stop you from getting caught out. So I hope that today has helped you also. That brings us to the end of our webinar. Thanks so much for joining me. I've really enjoyed having you on board. If you've got any questions, then do pop them in the questions section and we'll be able to come back to you after today's event. At Ellis Whittam, our employment law advisors and health and safety consultants are on hand to help you understand your legal obligations and make any process easier and smoother. And so if you have any questions about our services generally, then get in touch. Our contact details are right there for you and will be in our follow-up webinar email. We also have a whole host of other webinars this month. We have employee handbooks on the 23rd of June, and we also have a holiday special on the 29th of June. So do feel free to join me on those. The details will be in your follow-up email. I hope you've found today helpful, and I hope you have a great rest of your day.